some subtext on the intention of this panel. As I understand it, or from my vantage point, most school board members are not legal scholars. And even if they have any experience as a lawyer, they may not be, they haven't specialized in education law. So my job here is to ask the dumb questions that maybe some people in the room have. We don't want to, the discussions among great legal minds between Pickering versus this, and all of the legal cases are great, but school board members want to know, okay, can students wear shirts that say "Bong Hits for Jesus"? Can teachers wear crosses? There are very clear questions and difficulties that come up. So my job here today, hopefully, is kind of asking some of the questions that you guys have on mind and translate all of the high legal theory for you all. Before we get into the particulars, though, Rick, I was hoping just kind of as a framing 10,000-foot question to get clear on our terms, you could help us differentiate between two different concepts. The first one, the difference between speech that is morally right and wrong and freedom of speech as it fits into the law.
Right. So the First Amendment to the United States Constitution says that Congress shall make no law abridging the freedom of speech. Now, the more astute might say, well, it says Congress shall make no law. Why? What does that have to do with the state of Wisconsin? What does that have to do with the Greenfield School Board? And for many years, that was a valid point, right? The First Amendment only applied to the federal government. But after the Civil War, there were post-war amendments that were part of the Reconstruction process. The 14th Amendment imposed upon the states a prohibition against deprivation of life, liberty, and property. It imposed an obligation of advancing or protecting equal protection, and couldn't deny equal protection to citizens. And the courts engaged in this legal fiction called incorporation, and it said what the 14th Amendment did is it made some of these, not all, but some of these rights that are set forth in the Bill of Rights, like the First Amendment, applicable to the states. And so this prohibition against restricting speech applies not only to the federal government, but to the state of Wisconsin and to the Greenfield School Board and all other school boards, basically against government. And so the prohibition seems absolute, doesn't it? No law abridging the freedom of speech. But like everything in the law, it has become much more complicated because really that's what lawyers do. We complicate things. Because if we didn't complicate things, well, you wouldn't need us. So we can't have that. I think Dan's question goes to, we'll talk about exceptions and how this applies later on. But I think Dan's question goes to this notion of, well, why do we have this guarantee of freedom of speech? Because we all know that there are types of speech that are bad. There are types of speech that are false. There are types of speech that are hateful. There are types of speech that are defamatory. We know all these things. So why do we protect this stuff when we know it's bad, or when most of us, 98% of us, would look at a particular statement and say, nobody should say that? And so an example that I like to use is politicians will frequently say, well, we can't have hate speech. We must prohibit hate speech. No one has a right to engage in hate speech. And the fact of the matter is, the legal fact of the matter is that you do have a right to engage in hate speech. Hate speech is not an exception to the First Amendment. And the reason for that is not because we think hate speech is good, but because it's not a self-defining term. People will differ on what it is, and we don't trust the government to distinguish between what type of speech should be labeled hate speech and therefore prohibited, and what type of speech is not and therefore will be permitted. The catchphrase that you will often hear is that the remedy for bad speech is more speech. That is, if we don't like what somebody is saying, the remedy isn't run to the government and shut them up. The remedy is to respond to what they're saying, because we believe that as a general matter, not perfectly, not all the time, not absolutely, that the truth will out. And so this is the philosophy behind the First Amendment. It is a judgment about the power of government and the value of open discourse. It is not based upon a premise that all speech is equally good. And so there's a distinction between protected speech and good and moral speech, because there is speech that is protected by the First Amendment, but not speech that most of us would regard as admirable or something to be encouraged or that we would engage in.
Thanks for that. Second framing question, talking about the difference between perhaps legal consequences for freedom of speech and personal consequences for speech. I work for an explicitly conservative organization. I'm sure if tomorrow I started talking about how great Mom Donnie's policies in New York are and how we should be implementing them, my boss might sit me down and say, Buck, you're a nice guy, or like, I like to think I'm a nice enough guy, but this isn't the organization for you. Or a restaurant worker starts berating the customers there. They can get fired for these things. So what's the line between legal consequences and personal or professional consequences?
Okay. So one important distinction to make, and we kind of hinted at it in response to the first question, is to whom does the First Amendment apply? Who is prohibited from restricting speech? And we know that it's the federal government. We know it's state and local government. It is the government. So you will hear people say all the time, when somebody does something like, fire a nice guy like Dan Buck because, he said something which is inconsistent with the interest or the policy perspectives of AEI. Well, he has a First Amendment right to say that. Well, yes, he does. And so the government couldn't do anything to him. But the First Amendment doesn't apply to private entities. And so, if somebody who works at the Wisconsin Institute for Law and Liberty went on social media and said Rick Esenberg and Dan Lennington are morons and you shouldn't listen to a word they say, in all likelihood that person would be fired. Now, I would be understanding, of course, but I'm afraid Dan would insist on termination. And similarly, the fact that somebody has a First Amendment right to say something doesn't mean that that we have to like it or that we have to regard what they say as somehow acceptable, right? Because we have a right of free speech too. And so if somebody, I'm not going to use any names, but if somebody, has a podcast or something like that, and they say Hitler was a real cool guy, I certainly have the right to say, look, that's an abhorrent decision, abhorrent opinion. It is outside the mainstream, and I don't want to have anything to do with you anymore. Now, there is, and I know, Dan, we talked a little bit before about a spirit of free speech. Although I have the right to, try to ostracize people that say things that I don't like. In a democratic republic where we have to live with one another, where we have to interact with one another, it's best that I do that sparingly. Not because I have a legal obligation to do it, I don't, but because we all have to live together. And part of living together in a democratic republic is to learn how to disagree. And, so one of the things I hate is every Thanksgiving, there are all these breathless articles in certain outlets about, well, drunk uncle is going to come over for Thanksgiving dinner and he's going to have his red MAGA hat on. And, you, young college student that's back, how are you going to speak truth to power? And, maybe you just sort of realize that everything is not politics and that you can disagree with somebody, you can not like what somebody says, but unless we're out at the extremes, perhaps it's something that you ought to be willing to tolerate and engage rather than ostracize and ban somebody to the hinterlands, not legally, but in the way that you interact with them.
There we go. Let's get into some of the particulars. First one, let's get perhaps the most controversial one out of the way up front. Last year, many of us watched in horror as Charlie Kirk was shot and murdered. And then even more horror and aghast as many teachers, public employees took to social media to celebrate his death. And then many of these employees then, within a day or two, found that they no longer had a job. Can they be fired for this? What are some of the guardrails and considerations for board members to keep in mind? Help us understand the issue of teacher speech outside of the classroom.
Right. So I think that I'll preface what I'm about to say about this stuff with the caution that the law is really mushy. We'll talk a little bit about why that is, but I mentioned earlier that AEI or will private entities, they can fire an employee if that employee, generally speaking in the United States, people are at-will employees unless they have a contract. They can basically be fired for anything unless there's a law like an anti-discrimination law that applies to them and protects them from discharge because of their some type of characteristic that they have that's protected. But other than that, you can be fired for looking at the boss the wrong way. And but what about when you say something and your employer is the government and they want to fire you? Can they ever do that? Does the government have interests as an employer, just like Will, just like AEI, that would permit them to do that? And the general rule is this: if you are saying something as part of your job, the answer is, yeah, I probably can fire you. So if, Dan is a math teacher and he decides to go into class all day, every day, and talk about ice and how much he hates ice, and he's not teaching math, the school district can fire him because he is supposed to engage in government speech. He is supposed to deliver the curriculum that they have. But what about if Dan is outside of the classroom? If he hears about Charlie Kirk getting shot, and he wouldn't do this, but he posts something about how happy he is that happened and how Charlie Kirk deserved it. And, there are, we can go on both sides of the ideological spectrum. At that point, and this is where it becomes mushy, the courts engage in a balancing test. They ask whether or not this government employee, this teacher, has said something on a matter of public concern. And if so, it might be protected, but the courts engage in a balancing test in which they, take into account whether or not this is likely to affect their ability to do their job in some way. That is, will this cause, does this evince an attitude that a teacher shouldn't have? Does this, will this cause disruption and a lack of order? And the thing about balancing tests, and we have lots of them in the law, we didn't used to have as many. Like 100 years ago, legal rules tended to be much more cut and dried. But the thing about cut and dried rules is that sometimes in their application, they seem to be wrong. They seem not to fit. And so there's been a general trend in the law to go to more balancing tests and things like that. Well, the problem with a balancing test where you're considering all sorts of different factors, how does this affect your ability to relate to students? Will this cause disruption? That type of thing. The outcome becomes indeterminate, and that's very difficult if you're a school board member and you want to know whether something is permitted or not, because sometimes you really don't know until the courts tell you. But I could go on, but I don't want to monopolize.
I was going to ask if that balancing test also applies to a few more concrete examples. If a teacher were posting, maybe not outright explicit, but lewd photos, them having an evening out with friends and partaking in certain green substances, or the pages of the Milwaukee Journal Sentinel, or a fringy website expressing their opinions. The Balancing Act applies to all of these. Is it disruptive to the school versus?
Right. Well, particularly if let's talk about speech in a matter of public concern. This was a matter of public concern, right? Prominent commentator gets shot. I think to some extent the devil would be in the details on that. It would be, so what did this teacher say exactly? And so, you have on one end of the spectrum, say a teacher goes on Instagram and says, I didn't want Charlie Kirk to get shot, but I'm not going to mourn him because I think his opinions were noxious and very, very harmful. Maybe it's hard to make a case that that person should be fired. Let's go to the other side of the spectrum. Charlie Kirk got what he deserved. And moreover, I think that everybody that has those backward troglodyte opinions that Charlie Kirk had and believes in this and believes in that and believes in the other thing, the same thing should happen to them because they are not even human. Now, this may evince an attitude. A school board might conclude that, okay, this person can't deal with people with whom he or she disagrees. This person has just pronounced that half of the students and family in our school district aren't even human. Maybe we don't have to tolerate that. Maybe that will cause so much disruption and raises such serious questions about the ability of this teacher to serve our entire community that we're entitled to fire them. I mean, there are more examples that we can talk about. Will had a case where we represented a teacher that was in Madison, in the state capitol. There was a rally about transgender transitions for minors. And this teacher, who was, incidentally, not conservative, she was a woman of the left, but she didn't, she was what's called a trans-exclusive feminist. She didn't believe in gender transitions. And she got up and she used some, very blunt language, lots of F-bombs about transgenderism. And I think at one point she said, nobody is going to transition on, I don't want people to transition on my watch. But at the same time, apparently in her job, she would work with people who were, going through, a gender transition. And so, we thought, well, look, she didn't say that she wasn't going to follow the district's policy, and so she's really speaking on a matter of public concern. This is outside of school. She's basically acting as a citizen who's engaging in freedom of speech. We lost that case. Another example is a teacher in Waukesha who used to sing the song Rainbow Land with her students. I've only heard Rainbow Land once or twice. I don't think it's much of a song, but that's neither here nor there. It's not as bad as Imagine, though. That's even worse. I'm sorry. That's a personal opinion. In any event, the school district said you can't sing that with your students. That's not part of our curriculum. That touches on issues that we don't get into with first graders. And so, she went on social media and she criticized the school district for their decision. Now, she didn't say she wasn't going to comply with it. In fact, she did comply with it. And my position, which was expressed publicly at the time, is that, she shouldn't be fired for that. That was, in my opinion, protected speech. I think the litigation is still going on, but the lawyer for the school district didn't agree, and she got fired for criticizing the school board. Now, the case is more complicated than that, and I'm sure I've left out important facts, but the problem is that anytime that happens, we are now in a balancing test world. Sometimes it's kind of easy, but sometimes it's kind of hard to know exactly what's going to happen.
So far, it seems like the takeaway is that it's unclear, and all of these cases it depends. I want to switch to teacher speech inside the classroom. I was an English teacher. Any fans of Romeo and Juliet out there? I'm sure there's twos of you, threes of you. It would have been a breach of contract if I went in there and talked about Star Wars all day, or the finer points of Lord of the Rings and Tolkien lore. Help us understand, the relationship between teacher autonomy. We can't and shouldn't micromanage everything that they say, but also the school board's role in setting curriculum policies, what should be the focus of the classroom.
So, there is a difference between what a school board can do and what a school board should do. So, it's one thing if you're just completely off tack and you're talking about Star Wars when you're supposed to be talking about Shakespeare. But what if you want to talk about something that the school board has decided isn't part of the curriculum? Like, okay, we don't talk to kids in grades K through 4 about human sexuality. We don't do that in this school district. I think the school district can do that. Whether they should do it is another matter. But when you're a teacher and you're in the classroom, you are doing a job, right? You're supposed to effectuate the policy of the school board, which gets to decide, because these are public schools, right? We have this constant debate that rages between public schools, private schools, choice schools, and there are people that prefer public schools. They think public schools are better. And, at will, we don't like to get involved in sector wars. We'd rather talk about a quality school rather than what sector it's in. At least we try to do that. We think that there should be choice schools. But what characterizes a public school is it's subject to political control. That is, elected representatives decide what you're going to do. Now, there are certain restrictions that, in anti-discrimination law, the state has a lot of requirements that it will impose on school districts, but a teacher is going to have to follow that unless courts at some point decide that this concept of academic freedom applies to K-12 teachers. And that hasn't happened yet. So academic freedom on the university level. Most universities have a policy of academic freedom, and they don't micromanage what professors can say in the same way that they do in K-12. And in one of the cases that involved public employee speech, Justice Breyer dropped a footnote and said that, there is this concept of academic freedom that might restrict the government's right to control the speech of educators in a way that's not present in other forms of government employment. That hasn't really gone anywhere. I don't know that that concept is going to really have legs in the K-12 context, but I think that school boards have a general right to control their curriculum. Now, that doesn't mean they should do it. That doesn't mean that they should stifle teacher creativity. They ought not to do that as a general matter, in my view. But a lot of times what we get when it comes to politicians' response and attempts to control speech in schools is they see a situation where they don't like what's happening in the schools, right? They don't like curriculum that they think is racialized. They don't like curriculum that they think is too isn't age appropriate when it comes to things like sexuality, things like that. And the other thing is that these legislators who feel that way, they tend not to trust school board and teachers, right? They see them as somebody who's hostile to their political control. And so a lot of times they will adopt a tough on crime approach. We saw this in efforts to rein in DEI curriculum in schools, where states would pass laws or school boards would adopt policies that say that no curriculum should make somebody about race should make somebody feel uncomfortable. Well, that goes way too far, right? I mean, if you're a student and you're learning for the first time about slavery, it ought to make you uncomfortable. It ought to make you feel bad. It's a bad thing. When you learn about the Holocaust, it ought to make you feel bad. It was a bad thing. But that really is more a matter of appropriate policy than legal command.
I think we have time for one more question from me before we turn it over to the audience, for a few from the audience. And because we're short on time, I realize I'm going to roll a few into one here, a few specific examples. But I'm thinking of personal displays, a teacher who wants to wear a cross, or I saw a colleague who was wearing a shirt on like a dress down day that had a raised socialist fist on it. So personal displays, maybe ancillary speech, where if I had a colleague get in trouble, a student came up and asked him, "What do you think about pride?" He was a devout Christian. He said, "I don't support it," and didn't get fired for it, but got the administration breathing down his neck. The student asked him for it. So personal displays, and the speech that comes up not through the curriculum, but just kind of on the side. Where does that fit in?
Yeah. So, I mean, I think that the law is evolving. So the example of a cross, right? You have this other sort of thing that's out there, which is the other part of the First Amendment, which says that the government can't abridge the free exercise of religion or establish a religion, right? And these things are kind of in tension, because if you impose secularism in the public schools, isn't that a form of establishment? That's a form of disfavoring religion. But yet, if you allow, religious expression, are you establishing a religion? Are you sending the message that the school district, endorses, Christianity or, whatever it happens to be? And the law in that area is really messed up and mixed up. There was a time when it was pretty, the Supreme Court in particular generally took a disapproving view of any expression of religious sentiment in the public school context, but it's backing off on that. There's a case a couple of years ago about high school teacher that would engage in voluntary. He was a football coach. He engaged in voluntary prayer after the game with any student who wanted to join him. So the answer is, the answer there is that it depends, and the important thing is that the school not engage in viewpoint discrimination. So if they're going to permit one kind of symbol and not other kinds of symbols that they don't like, they're going to run into trouble.